You know what? They're making a new copy of the DVD, so I'll have to remark that.
Okay. So,
And I have one other one.
okay. So we can proceed to,
And then there's one.
That's one reason why I started using this.
so this is
Because
two for the CD and
it helps, you know, you gotta keep this like this. Keeps them from falling off. It's like, oh my god, that's in my... That costs $150 to buy a double camera strap like that. Which they call them black rabbits. They're $150 maybe, they're 70, I don't know, they're expensive. Just like we always do. Which is what the other don't understand either. Somebody's home. They can hear all that.
Right. Go ahead, yeah. The tank. You know that the notice has to do with 768.27A. What that goes to?
No, there's one in domestic violence.
Yeah, I heard. So how do we surprise 403, I think? I mean, I'll figure it out. I don't see it.
768.27B.
Okay.
B is for domestic violence.
Yeah. Okay. Okay, so
There's still a weighing factor.
yeah, I know. I do.
Is the judge back there now?
She's fine.
Oh.
Yeah, just here, pull the roof and everything. Imported. Yeah, you see, we got so many different places here.
All rise. 31st District Court is now in session. The Honorable Alexis Pratt presiding.
Please be seated. It was
768.27B.
Judge, I think we may have a preliminary issue. If, sure.
We wait for your client?
Yes, I think so. Would be nice to have you.
Okay.
They probably think so.
Yeah, I know, Judge, but they can help you with this one.
No, that's true.
Okay. Okay, so. Let me just make sure it's on. 768, okay. So you need 768.27B. I got it. And like you said, that's your their weight, the weight that you give it. regular statement. Okay. Well, let me see.
Yeah.
Okay. Yeah, I will. And I trust you, too.
No, I'm not sure, no, but I'm not going to come in. I'm not going to never read it, but it's short.
Okay.
I'm just going to add it once a week.
Oh, okay. Okay, yeah.
Everything is
Okay. Okay.
That's fine.
Just
fair. Come back.
For decision.
Yeah.
That's
Maybe,
right.
maybe Judge?
Okay.
Okay.
This is People of the State of Michigan versus Christopher Olinger and Markham, 169741FY. Good afternoon, your appearance, please.
Jennifer King for the people.
Just good afternoon to you and your staff. Lillian Yao on behalf of Christopher Olinger, who is present to my right.
Good afternoon, Your Honor.
Christopher Olinger.
Good afternoon, Your Honor. Wyatt Harris on behalf of Asia Markham, who sits to my right.
Do we have any preliminary matters that should be addressed?
Yes, we have a couple, and I'll let Mrs. Ting start out.
The first is we have statements that both defendants made that the people intend to introduce into evidence. We were discussing that due to the length of them, it would probably be easier to take all of the testimony today and then leave this with you to watch when you can and then have us come back for a decision.
Yes, because they're several hours long, Judge.
Okay.
No objection.
All right, so you all stipulate to having me watch the statement ex parte.
Yes, ma'am.
Yes, we trust that you're going to watch it. You rule fairly.
Okay.
Right.
We can't, Judge, we're not going to sit here and watch you watch the videos. That would be a waste of everybody's time.
It's not my time.
Right.
But,
Yes, Judge.
okay, I don't get, if the three of you don't have a problem with
No.
that, then I don't have a problem with that.
Thank you.
Okay, so we'll do that. Okay. And have both of you seen, it looks like Ms. Tink has a thumb drive, flash drive. You're sure, I don't want you to say afterwards, I saw some other information on it.
Well, just let me say, I've known Ms. Tink for a very long time. I would trust that what is on her flash drive is the same statement that she gave me concerning Christopher Olinger, and I only speak for him. She has the utmost integrity in my book.
I
appreciate that.
I trust that the statements that were made by my client and the video that I have of the statements made by my client are also on that thumb drive, and I don't believe that she would do anything nefarious with regards to that.
That's right.
So that's how we'll do that.
Okay.
Any other?
Oh, yes, ma'am.
Okay.
The second issue is going to be a little more involved, and that has to do with defense's objection to the prosecution's notice of intent to use other act evidence pursuant to MRE 404B and 768.27B. Quite simply, Judge, we would object to that. There are a couple of areas in which we don't believe it would survive MRE 401, 402, or 403. When you read this laundry list of things, it's just, it's not appropriate at this particular level, Judge, and I can read to you the research that I've done to say why this is not applicable. Mrs. Tink quoted, I believe, People versus Watkins in this particular case, and People versus Watkins is at 491 Mish 450. It is a 2012 case. It goes to applying MRE 403 to evidence which would otherwise be admissible under 768. So there's a weighing factor that the court must do, Judge, to see if it's more probative than prejudicial. We would contend, and I would contend on behalf of Mr. Olinger, that it is more prejudicial. There's absolutely no probative effect that you can get from the allegation that there may have been domestic violence involving him and Ms. Markham. It's so tenuous, Judge. What we're here about, unfortunately, is the death and the homicide of a child. And we would ask that that evidence that comes in directly goes to that particular issue that we have before this court. Thank you.
Your Honor, I argue that 768.27B is not applicable as one that doesn't go to domestic violence. But also, I don't believe that given the evidence, this ruling would apply. I think that there's speculation on the part of some witnesses, and given that speculation, this rule definitely would not apply.
The people filed the other acts notice kind of cover our basis, but the truth is that this isn't even necessarily just another acts situation. This is a situation where this evidence is being used to show that Ms. Markham was on notice that her child was being abused by Mr. Olinger. It's really not being used against Mr. Olinger, as I admit we don't have definitive proof that he injured the child in the past, and therefore I don't think it should be used against him. However, we're using it against Ms. Markham to show that she knew her child was being injured by Mr. Olinger and yet still left her child alone with him, and thus created a situation in which she was able to take it to the ultimate end, which was to kill the child.
Judge, if you listen to the comment of the prosecutor, she just said that we do not know that Mr. Olinger injured the child. Well, if Mr. Olinger didn't injure the child and they don't know that he injured the child, then how in the world can it be assumed that Ms. Markham thought Mr. Olinger injured the child and left the child in his care, if they didn't know that he injured the child?
Well, I think that's for them to show.
Absolutely, Judge, and I guess I'm confused about with the circular argument that we just had. Circular, I'm sorry. I don't understand it, Judge. If there's no evidence that Mr. Olinger did anything to injure this child, and that's what we're talking about, how in the world could there be evidence, and I'm not trying to speak on behalf of Ms. Markham, because she has an attorney that can speak for her, I speak for him. How in the world can that be imputed to another party if you don't have that evidence? And then the question would have to be asked, if you don't have that evidence, why am I even talking to you right now, and why is he sitting at this table? So I think there's an issue with causation. I think that's what the prosecutor is trying to say, but I object. But she says, you are using it against me because you're saying he did something. That is speculative at very best.
See, what the prosecutor wants you to assume is that Mr. Olinger did something prior to this child's death that would cause Ms. Markham to know that Mr. Olinger did something. And But the problem is, she just told you that they don't know that Mr. Olinger did anything prior to this death. They can't say that.
Ms. Tink, do you want to clarify something?
I can't prove that Mr. Olinger was the one to abuse the child. What we intend for the evidence to show is that the child suffered injuries that are not consistent with accidents and not consistent with day-to-day being a child, and therefore, since the other testimony will be that the only people that were around this child and were taking care of this child were the two defendants. Therefore, one of them was causing these injuries to the child, and the other one had to know it was going on.
You're offering to prove she knew or should have known.
Yes.
Not that he definitively
Did those acts, correct.
I'm going to allow that.
Okay, we object to under everything. We say a 40, I think I said, let me just make sure the record is clear. Under 403, 401, 402, and let's see, under state as well as federal constitutional law. Thank you so much, Judge. I just have to preserve it.
I join counsel in that objection.
I understand that.
Thank you.
Ms. Tink, I'm looking for the file to see when you filed your, here. She filed it November 15th, so I appreciate you both think I'm making the wrong decision, but you had a month to respond in writing.
But we also, we got a month, Judge, that was just notice, that we were supposed to get a month's notice before we even brought that up. But it's okay, Judge, we respect this court's ruling.
Any other preliminary matters?
Nothing on behalf of Ms. Mark.
Oh, motion,
We'd ask for a motion for mutual sequestration.
that is correct, Judge.
Yeah, no objection to that.
Motion granted.
Thank you.
Is there any witnesses in the courtroom? Other than,
If you are a witness in this case, you have to step out, so you will not be allowed to testify in a later proceeding. So if you're a witness, and all in this case, you have to step out.
are you asking for an exception for?
I am asking for an exception for the officer in charge, Detective Crackiola,
No objection to him.
and the co-officer in charge, Detective George.
You're going to ask you for that? With that?
I'm sorry, Judge, I was talking about time, so I did not hear what was going on.
I don't have the objection to the OIP,
All right, are there any other witnesses other than Detective George and Detective Crackiola in the courtroom?
On behalf of Mr. Olinger, I've identified no one, Judge.
On behalf of Ms. Markham, I've identified no one, but I have sent ladies out of court.
Any other preliminary matters?
No.
Just one second, somebody there. Yes, ma'am. Okay, Judge, and I would defer to Ms. Tink on this one. We have a prospective witness for Mr. Olinger who would testify, and I don't even think this is something we'll get to today, that she's left her children with Mr. Olinger numerous times and there's been no harm that ever befell them. He's a very good caretaker. Is she right here? Oh, okay, maybe you can step out. Should she step out? Yeah, just step out because if you're a potential witness. I don't think she is. I'll figure it out.
Are you ready to proceed?
Yes, ma'am.
Yes.
Are you going to give opening statement?
Oh, no.
Okay. Then please call your first witness.
We call Dr. Sung.
State your name for the record, please.
My name is Lachlan Sung.
And then L-O-K-M-U-N,
M-A-N.
M-A-N, and S. Spell your name for us.
S-U-N-G.
Okay. Raise your right hand. Do you swear or affirm the testimony you are about to give is the truth?
I do.
Have a seat in the witness stand. Officer Fox will adjust the microphone for you.
Please state your name for the record.
My name is Lockman Sum.
And what is your occupation?
I'm an assistant medical examiner at the Wayne County Medical Examiner's Office.
Okay. I believe there is a stipulation from defense counsel that Dr. Sung is an expert in forensic pathology.
No, for preliminary exam purposes only, no objection on behalf of Mr. Olinger.
For preliminary exam purposes only, on behalf of Ms. Asia, we have no objection to him being ruled as an expert in forensic pathology.
So I'd like to bring your attention back to October 26, 2016. Did you perform an autopsy on an Amina Markham?
Yes,
And do you know how old Amina was?
she was reported to be 1 year, 4 months.
And during the performance of the autopsy, were you able to determine a cause of death?
Yes,
And what was that cause of death?
the cause of death was multiple blunt force injuries.
Okay. Can you describe for us the injuries that Amina had?
Externally, or on the outside of her body, she had a number of blunt force impacts to her face and skull. In total, there were 5 on the right side of the face, 7 on the left, and 3 to the back of the head. There was also a small abrasion above the right, the left ear, and also on the left shoulder. Internally, there were additional injuries that were identified. There was bleeding or bruising on the rib cage, on the aorta, which is the major blood vessel that delivers blood to the body. Also the esophagus, which is the tube or connector that connects the mouth to the stomach. In addition, there was bleeding and bruising on the diaphragm, which is the breathing muscle of the body, also on the right adrenal gland, and multiple tears or lacerations on the liver.
Did you say liver, sir?
Yes, I did. After examining the organs, it was noted that there was approximately 60% of the child's blood volume within the chest and abdominal cavities.
What does that indicate to you?
It indicates that there was significant bleeding inside the chest and abdomen, the cavities. After the blood was removed and measured, I noticed that there were fractures in 2 portions of the vertebral column of the spine. After examination of those fractures, I also looked at the spinal cord, and there was bleeding around the spinal cord at those locations.
Were you able to determine what the manner of death was?
The manner is classified as homicide.
And why is it classified as homicide?
There are 5 manners of death that we must classify cases into. Those 5 are natural, that's where death is strictly due to the internal disease process. Homicide, where death is due to the actions of another individual. Suicide, where death is strictly due to a person deciding to end their own life. Accident is where death is an unpredicted outcome, such as if you're driving a car and slide on ice and strike a tree or a cement barrier. And then the last is indeterminate. That's where there's insufficient information to choose one of the other 4. In this case, the injuries were not due to a natural process. It is my opinion that these injuries were not due to a suicidal intent or action, and also not accident. And therefore, it leaves me with homicide.
And how are you able to determine that this is not an accident?
The totality of the injuries would not be sufficient for an individual of this age to sustain.
Okay. Could this have been caused by a fall from a changing table or something like that?
One bruise may be, however, the extent or totality of the injuries would not.
I have no further questions.
Mayor? Yes. And good afternoon to you.
Good afternoon.
Okay, can you tell when any of these injuries befell this child? The age of any of the injuries?
I cannot tell you a precise age. I can say that they all occurred around the same time.
And when you say the same time, you can't give me, was it a week before she deceased? Was it a day before she deceased?
It was relatively shortly before she passed away.
And when you say relatively shortly, could you try to quantify that for me?
It depends on individual's physiologic status. However, in general, it would be a few hours at most.
A few hours at the most?
Yes.
Now, so these cluster of injuries, could they have been put on this child at varying times?
The appearance of the injuries were all contemporaneous or similar in appearance.
Okay. So when we say contemporaneous or similar in appearance, they all happen, you believe, around the same time shortly before her death, correct?
Correct.
Okay. So this is not a situation in which this takes place over a week or a month or a year. This is something contemporaneous with hours, and this child deceases, correct?
These injuries, yes.
These injuries that caused her untimely death,
Yes.
correct? Okay. And I don't have any other questions. Thank you. No.
Mr. Harris, go ahead.
There were absolutely no injuries that were dated.
No, we do not date injuries at our office.
Well, okay, let me reword that. There were no injuries that appeared to be old injuries?
No.
No. Every one of these injuries were what you would consider fresh and new injuries.
Yes.
And your cause of death is blunt force trauma?
Multiple blunt force injuries.
Okay. Could you tell from looking at the injuries what kind of blunt force trauma took place? Let me give you an example. Could it be by hand?
Yes.
Okay. Could it have been by some other type of an object other than a hand?
Yes.
Were you able to identify what object it might be?
No.
No further questions.
Just briefly, how soon after a child experiences these injuries would they start to show symptoms of not being okay?
The symptoms would be immediate.
Okay. Also, may I approach the witness?
Yeah.
I'm going to hand you People's Proposed Exhibit 3.
Yes.
Just one second.
Everything.
Everything. Okay.
If you could tell me what this is?
People's Proposed Exhibit 3 is a copy of the autopsy report that I generated, and it includes the body diagram, which I generated, and also the toxicology report.
Okay. And this is for Amina Markham?
Yes.
I move for the admittance of People's Proposed Exhibit 3.
No objection, no, for exam purposes only, on behalf of Mr. Owen.
On behalf of Ms. Markham, Your Honor, no objection for exam purposes only.
No further questions.
Exhibit 3 was admitted. Do you,
Yeah, I do. Is this what he generated? Is that part of it? Okay, so the initial circumstances, and I don't know if that's part of what you have, was cardiac arrest in bed, found by mother, no trauma, foul play notice, correct?
I'm not sure what piece of paper you are referring to.
Is that what y'all gave?
I mean, that's what they gave you last time.
Yeah. May I have permission, Judge? Have you seen the case registration summary, sir?
Yes, this is page 1 of 2 of the case registration summary that is generated by our medical examiner investigators.
Okay, and that's how it starts off, correct?
Yes.
Okay. And the circumstances, you don't know if it's who gave the circumstances, correct?
Correct.
Okay. It would be the investigator whose job it is to investigate whatever started or did not start at that particular time, correct?
That's correct.
Not another question. Thank you.
Let me ask you, that document that you had, the case summary document, did you get that before you conducted the autopsy?
Yes.
And so you had some prior information as to what might have happened with this child prior to you conducting the autopsy?
The information I had was strictly on the case registration summary. So yes, I had that prior to autopsy.
Now, you took photos of the child, correct?
Yes.
And in your photos of the child, you took photos of the child without having any incisions provided by you, correct? So you just took photos of the body?
There are some photos prior to the incisions being performed, yes.
Correct, okay. And was there anything in those photos that you looked at prior to incisions being performed that would cause you to say what the cause of death was?
In the photographs of the head, there are clear-cut bruises on the right and left side of the face, and after shaving a portion of the hair, bruising was seen on the back of the head. And the number of bruises on the face and head immediately preclude a natural manner of death.
Would the bruisings on the, and when you talk about bruisings on the face, I'm looking at the child's right side of the face. Would you say that those bruises would cause death?
In and by themselves? No.
Yes.
No.
Would you say that the bruisings that are on the left side of the child's head, would you say that those bruises would cause death?
In isolation, those bruises would not cause death.
The bruises that are on the right side or the left side of the child's face over the ear, would those cause death?
In isolation, the bruise and bruises would not cause death.
And I see you have the photographs there. The bruise that's on the back side of the child's head on the left side, closest to the left ear, would that, I believe I see 2 or 3 sets of bruises, would those bruises cause death?
In isolation, those bruises would not cause death.
Now, would those injuries that you said were to the spine, would those injuries cause death?
In isolation, those injuries would cause death.
Okay, thank you.
Anything else for this witness? Thank you, Dr.
Henrik is one of the first responders.
What about this? What about this?
That's a good question. I don't know if you authored the report. Did you author a report? Oh, you didn't? Okay.
Oh, well, there you go.
You were part of the cruise, all right?
Yes.
The very first one, cruise.
Cruise, okay. Cruise.
State your name, please, and state and spell your name, please.
Hemrick, H-E-M-E-R-Y-C-K, for St. Michael.
And raise your right hand. Do you swear or affirm the testimony you're about to give is the truth?
Yes, sir.
Okay.
Please state your name for the record
Officer Michael Hemrick,
and your occupation.
police officer,
And what city do you work for?
City of Hamtramck.
I'd like to bring your attention back to October 25th of this year, around 11:30 in the morning, did you go to 2645 Comore in the city of Santa County?
Yes, ma'am.
And what was the reason why you went to that location?
We were dispatched for a baby not breathing.
Were you with anyone else at the time?
I was with Corporal Cruz, who was my partner.
And what happened when you arrived at that location?
Officers were at the front door trying to, they were knocking on the door trying to get somebody to open it, and then I heard Miss Markham come screaming down the side of the house with her baby, saying, "Help my baby, help my baby."
You said you saw Ms. Markham. Do you see that person in the courtroom today?
Yes, ma'am.
Can you please point to them, describe what they're wearing?
She's wearing a gray sweater with a white collared shirt.
Does the record reflect the witness who identified the defendant, Markham? So she came from the side of the house, you said?
Yes, ma'am, on the west
Do
side.
you know, was there an entrance to the house at the side of the house where she came from?
I found out later that the entrance was on the back side of the house.
Okay. So you didn't see her, did you see her inside the house at all, or did you not see her until she was outside the house?
Not till she was outside the house.
Okay. And she came running towards you?
Yes, ma'am.
And what did she have with her?
She had her baby in her hand.
Okay. And did she hand her baby to you?
Yes, ma'am.
And what did you do?
I immediately grabbed her and started doing chest compressions, and then set her on the ground and started doing chest compressions, trying to revive her.
And how long did you do that for, if you recall?
Felt like a long time, but it was probably about maybe 4 or 5 minutes before MedStar got on scene.
Okay, and that's the paramedics?
Yes, ma'am.
Okay, and did they then take over
Yes.
for you? Okay. Did you have any conversation with Ms. Markham at the scene?
No, I did not, other than,
And was there did you see anyone else at the scene? Besides officers?
there were neighbors standing around. A neighbor on the east side was out on his porch.
Okay.
And there were other neighbors down the street and behind us.
Did you ever go inside the location?
After leaving the hospital, yes, I was there during the search warrant.
Okay. But when you were there, after the rescue effort, you did not go inside the house?
No, ma'am.
Okay. I have nothing further.
Yeah, and are you aware of the 911 call in this particular matter? Or no?
No, I did not hear the 911 call.
That's fine. And just so we're clear, what time did you arrive on the scene?
I'd have to look at my report for that.
Okay.
It was, and as far as I know, it was just minutes after we got the 911 call.
Okay, and just so we're clear, the person who's to my right, you did not see that person there, correct?
That is correct.
Okay, and the person to my right would be identified as defendant number 1, Christopher Olinger. And you did not see him at the time you were there, correct?
That is correct.
All right. Not another question.
No questions of this witness.
I'm sorry, what did you say?
No questions of this witness.
Okay.
No further questions.
Okay, thank you, Officer.
I think we were remiss, just before we get going good, that there is no statement that either one of them make against each other should be admissible. I think it's under Bruton. Is it Bruton?
I agree with you.
You agree? Okay, yes. I just wanted to make sure, Judge, because I didn't do that. I was remiss. So whatever she said doesn't go to Mr. Olinger.
Okay.
I join counsel.
Thank you.
With questions. And it's People versus Bruton. Read the cases.
Also, it's U.S. versus Bruton.
U.S. versus Bruton, excuse me.
No.
State and spell your name.
Shantavia Markham, spelled S-H-A-U-N-T-A-V-I-A.
And your last name.
Markham, M-A-R-K-H-A-M.
Raise your right hand. Swear or affirm that the testimony you're about to give is the truth.
Yes.
state your name for the record?
Shantavia Markham.
And do you know someone by the name of Asia Markham?
Yes,
And who is that?
my sister.
Do you see her in the courtroom today?
Yes.
Can you please point to her and describe something she's wearing?
She's there. She has on the bracelet.
Let the record reflect that witnesses identify the defendant Markham. Did you know someone named Amina Markham?
Yes,
And who is that?
my niece.
Was that Asia's daughter?
Yes.
And when Amina was alive, did you see her often?
I seen her every blue moon. I lived in Ypsilanti at the time, but I would see her sometimes.
And did you ever see Amina with any injuries?
Yes.
And what injury was that?
Her leg.
Okay, and how was it injured?
She walked with like a limp, I guess, and her mom said that she was playing and jumped off the toilet or something like that.
So you said she was walking with a limp?
Yes.
Amina was?
Yes.
And her mom, Asia, said she jumped off of the toilet?
Yes.
And that's how she hurt herself?
Yes.
Okay. Was there, I have no further questions.
No, not one question of this witness.
Mr. Harris?
You would agree with me, ma'am, that you didn't see prior to Asia's death, or Amina's death, prior to Amina's death, you didn't see Amina that much. Is that correct?
No, I did not. Not as much as everybody else did, no.
You testified at an investigative subpoena, correct?
Yes, I did.
And you testified truthfully, is that correct?
Yes, I did.
You understood that it was under the penalty of perjury if you did not testify truthfully, correct?
Correct.
And you remember testifying at that investigative subpoena that you didn't see Amina much, correct?
Correct.
You didn't see Asia much, is that correct?
I saw Asia more than I saw Amina.
Well, but you didn't see Asia much, is that correct?
Correct.
Okay. And you also testified that any information that you would get would be through one of your other sisters, is that correct?
Correct.
And which sister is that?
It was my sister April. It was also other family members as well, so it was not just one family member.
Okay. Now, when did you have this conversation with Asia regarding Amina jumping off the toilet?
I had this conversation with Asia after I had spoken to my sister Miracle because of the relationship with my sister Miracle. They had a close relationship, so I thought it would be more fitting for her to speak to Asia about it. And after Asia and Miracle had spoken, Asia texted me in regards to it, and she said that I could have come to her, which I felt like I said, the reason I went to Miracle was because I felt like it would have been more comfortable for her to do. And at that point, she had told me that Amina was a very active child, and she never left Amina with Christopher. And she told me that she was playing and jumped off the toilet, and yeah,
Would you
that point.
please answer my question? I asked you, when did you have this conversation?
I had this conversation. I don't know the correct time. I don't know the exact
Let
date.
me finish my question.
Okay.
Would you please tell me when you had this conversation with Asia regarding Amina jumping off this toilet?
Again, I don't have an exact date, but it was a
What
few
month?
weeks before. What month?
Yes.
It had to be in about September
September of what year?
of 2016.
And where were you when you had this conversation with her?
I was at home.
At where?
No, we were talking via text.
So
I
you
was
didn't-
at home.
So you didn't have a conversation, is that correct?
It was a text message conversation, technically.
Excuse me.
Mm-hmm.
You and I are having a conversation, correct?
We are verbally,
I'm
yes.
seeing you, you're talking to me, I'm talking to you, correct?
Yes.
You did not have that type of conversation with Asia,
Mr.
is
Harris,
that correct?
I think you're getting a little aggressive.
Right, because you never said verbally. It was a conversation. It was not a verbal conversation, but we had a conversation
Okay, so
via text message.
So you had a text message conversation with Asia regarding this child jumping off a toilet, correct?
Yes.
You did not see any injuries on this child, is that correct?
Again, I saw, because of what had happened with her supposedly jumping out the toilet, yes, Amina did have, she walked with a limp. No 1-year-old should be walking with a limp.
Please answer my question. Did you see an injury with regards to this child?
No, I did not.
Thank you. Now, you said you had a text message conversation through your cell phone, is that correct?
Yes.
And through Asia's cell phone, is that correct?
Yes.
Your Honor, I'd like a matter of discovery to get the text messages of this witness and their cell phone with regards to September, and I'll supply this court with an order of discovery for that.
I'm sorry, we're asking for
Her text messages that she had in September with my client regarding these injuries.
We've already done a phone dump for a forensic evaluation of the defendant's phone, so the text messages should be in there under September.
I'd like a phone dump of this witness's phone.
I don't think this witness should be obligated to turn her phone over for a phone dump when all the information is in what we already have.
I don't know that this witness is testifying that she had a text message conversation with my client. To confirm that this witness is being truthful about that, that's why we would need her phone records.
Well, it's not a matter for phone
not
records.
available on...
I don't know that it would be available, but I surely want it. If this witness is saying that she had these phone conversations, these text message conversations, she ought to be able to provide it.
She's not obligated to prove anything. I mean, that's the people's obligation. If we want to get those phone records to prove that they exist, then that's up to us and our obligations. But this witness should not be obligated to turn her phone over because defense wants it.
Excuse me, Your Honor. I'm cross-examining this witness. This witness will probably be cross-examined at trial. If I could have those text messages to verify that what she is saying today is truthful, that's the reason I would want her.
My question is, doesn't he already have that information from what Ms. Tink just referenced as the phone dump of defendant Markham's phone?
The answer to that question is no, Your Honor.
I wasn't asking you.
Oh.
I was asking Ms. Tink.
Okay, I'm sorry.
We have the complete phone dump of the defendant Asia Markham's phone. There's no reason, even if messages were deleted, we still have access to them. I'm receiving it now. It's big enough to fit on, and only to fit on a 32 gigabyte flash drive that has not yet been turned over to defense counsel, but everything that this witness is testifying to should be on the defendant's phone if they had a text conversation.
And you're asking about the conversation between these two ladies, between the witness and your client?
That's correct.
Okay.
The text message conversation.
So that information is on your client's phone, which Ms. Tink has.
I deeply apologize. Apparently we already have done a forensic evaluation of this witness's phone, which I will gladly turn over to defense counsel as soon as I can get something to copy of that.
Thank you very much.
That matters. Okay. Were there any other phone dumps that you want to let them know about?
We have 3 total. There was one done of April's phone dump that I believe that was turned over with discovery. I'm now finding out about
We did April.
Shantavia's.
Shantavia's, we did that at the IS.
Right.
We did both those at the IS. And we have,
This is April's.
we
Do you mean Asia?
have Asia's.
I don't have
And they're at the crime lab still working on it.
Okay, the other two, the crime lab is still working on. So there's only one that I have in my possession I'm receiving today. That's this witness's. The defendant's phone and both defendants' phones are still being worked on. As soon as I have those, I will turn those over to the defense.
Okay. So, Mr. Harris, are you satisfied with that?
Yes, Your Honor. Then turn that over. That'd be fine. I have no further questions at this point.
Okay.
Oh, no, I'm sorry.
Judge, I just wanted to clear up something that Mr. Harris said. I couldn't hear it. Did you, may I, Judge, just...
Yes.
I'm sorry, and Ms. Shantavia Markham, did you testify that per some conversation with Ms. Amina Markham that she indicated she never left? I'm sorry. I'm sorry, Amina's the baby, I'm sorry. That Amina, the baby, was never left alone with Christopher, correct?
Yeah, she did tell me that.
Okay. Not another question. That's what I thought I heard. I didn't know. Thank you so much. This baby.
I have no further questions.
Okay.
Thank you, Ms. Markham.
Okay.
We're going to do it. To put in the statement. Were you stipulating to the statement? Are you stipulating to the statements coming in? Do I need to put Jack in the statement?
To my client's statement?
To both of you.
She's going to look at the statements.
Right.
Right?
So we're stipulating.
Just for the only,
For exam
purposes
I understand.
only.
Okay. At this time, I move for the admittance of People's Proposed Exhibit 2. This is the statements of each defendant, only to be used against themselves and not against each other.
Yes. No, on behalf of Mr. Olinger, no objection, Judge, for exam purposes only. And I think it's just one statement of his, right?
Yes.
Okay, he's just on there once.
Okay.
Your Honor, I think that my client, Asia Markham, is on there twice, and for exam purposes only, we would stick.
And then may we approach?
Yes.
This way, Judge.
That doesn't go anywhere.
Yeah. Okay. Yeah, watch myself. Thank you.
The people's last witness for this exam is going to be April Markham. She has not shown up. She has refused to tell the officer in charge where she is located, although she assured us that she would be here today. Her family members indicated to us that she was on a bus from Redford. That was at 1 o'clock. At this point, we would be asking for a material witness detainer on her and ask to continue the exam for approximately a week so that we can attempt to locate April Markham and bring her in to testify.
Yeah, well, of course, Judge, it's up to the Madam Prosecutor and the court, so I leave it within this court's discretion.
Mr. Chair?
Right, leave it in court's discretion.
Well, I do have to watch the videos that we stipulated to, and we've all agreed that I'll watch those and render a decision on another day. So I think we can have April give her testimony that day as well. Okay. So when are you, what's a day that works for the three attorneys?
Next week. Well, Judge, any any day other than the 21st is good for me. I'm supposed to start trial, but I don't believe that's going to happen.
Judge, I can't do the 21st or the 22nd.
I have 2 exams already on the 20th. Could we do the 19th?
Yes, if that's good for you. What time?
We're busy.
Oh, Judge, what are the dates for you?
Not the 19th.
Okay.
I don't know what days the court is open coming up.
We're open Tuesday, Wednesday, Thursday.
Oh, there you go.
We could do the 19th in the afternoon.
Okay.
I don't know if that's enough time. You said these videos are hours and hours, though. So I don't think that's enough time.
You're talking about 6 hours.
Okay.
And they're tedious.
No, my class wasn't that long. It was Mr. Harrison.
So
Monday would be, given, I'm not sure what the court schedule is, but I can assure the court you're going to need some time to really...
Could we go into the following week?
No, that's Christmas weekend.
It is. I'll be
the
here.
week after.
Oh, no, that's New Year's, Judge. Okay, wait, hold on.
Well, the week after that's my birthday.
Oh, no, that's not a good week
There's a
either.
lot of holidays.
Okay, Judge, if we do,
We're available in the afternoon.
On the 22nd?
On the 19th.
okay.
No, Mr. Harris said he's not available.
No.
I'm not available on the 21st or 22nd, Judge. I'm going to try.
Okay. So that puts us in the afternoon on the 27th, the 28th, and then the 29th, we have a combined docket with Highland Park, so I don't think that's going to work.
Oh, let's join that.
Well, Judge, whatever date will work in the afternoon for the court, just so the court knows, I'm available any date next week in the afternoon to try to accommodate any schedules. If not, then Judge, the week of, oh gosh, not the 26th though, Judge, please.
The 28th would be best for the people, because I have an exam on the 27th.
No, 28th in the afternoon is fine.
Okay,
The
good.
28th is fine for me.
That's good,
Okay.
Judge. Happy New Year.
Wait. Oh, wait a minute. No, we're not available on the 28th in the afternoon.
Huh?
27th. We can do the 27th in the afternoon.
I'm available on the 27th, Judge.
Not a problem.
What time is the
One.
1?
You tell us. We'll make it work.
I
Can we
plan
do 1
on,
o'clock?
I plan on not being in anybody's court, Judge. So I'm here for you.
I should be. I have an exam at 33rd District at 10:30, so I should be able to be here by 1.
1 o'clock, yeah. It's only one witness.
It'll be very quick.
Okay, so we can schedule it 1 p.m. on the 27th.
Yes, yes, yes. Oh, we can down here. 27. That's the date.
So, December 27th at 1 or 1:30?
Whatever time the court
Whatever,
says.
convene for the court.
Let's do 1:30. Just gives me a little more time.
1:30.
And I think if you're running late, just if you let us know, we'll let them know. And
Absolutely.
Yeah. Oh, shoot, but yeah, Tink can always tell. Yeah. We try to get along, Judge.
And then just put something in the chair and witness the case.
And I am planning.
1:30.
Yeah, 1:30. Okay. You know, I left the 911 tape in the attorney loud. Someone's cooking. Okay.
Okay, so are we done with what we can do today?
Yes,
I
ma'am.
think so.
Thank you. Judge and the staff have a wonderful day. Wonderful holiday.
Have your office call me if you can't watch it for some reason. I'll get you
She
instructions.
can do anything.
Oh, I know, awesome. We invite you around.
Okay.
Okay, so we're...
Okay.
you want to hold on to the autopsy real quick as well? Yeah, there's a picture that I'm going to put in with April. So it's just 2 and 3.
Okay, well, okay.
Judge, may I get my outerwear? Thank you. Because we're done.
You both have April's phone number.
I have them too, so look at yellow.
We can go back. It's for the order of recognizance for material witness. Do you have a recommendation in the bond?
We usually ask that once they're brought in, then we have a little hearing and we can discuss on the record why she didn't show up and how we can assure that she's going to come back. Because we don't want her locked up if she's arrested tomorrow until the 27th. We just want to make sure she comes back.
Okay.
See, that's why I love you. You know, you don't fight like that, but you fight like
I know you said it's LA, but you think he might be